Thank you. Please be seated. Good morning. Thank you for joining us today. It's a pleasure to be out in the community for this oral argument. We are here for oral argument in case number 1CA CV21-0495, Colgan versus Circle K. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. At least that's my understanding, that they are being video and audio recorded. Usually they are. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case in conference. You may proceed, counsel.
Good morning, Your Honors. My name is Matthew Marowitz. I am the attorney for the plaintiff in this case, or the appellant, Mary Florine Colgan. May it please the court. This is not your typical trip and fall case for the purpose of summary judgment, where defense argues that there wasn't notice or breach of that notice. The only issue for this appeal is whether the elevated concrete at the Circle K caused, and whether there's any evidence that the elevated concrete caused my client, Ms. Colgan, to trip and fall. And so long as there is any evidence in the record, whether direct or circumstantial, that can lead a reasonable juror to conclude that Ms. Colgan tripped on the elevated concrete, summary judgment is improper, and the Superior Court must be reversed in the decision in granting summary judgment. And I want to get one thing kind of out of the way, because the discovery, the briefs, the record, there's some phrases that are all interchangeable. There's the term hazardous condition, vertically displaced concrete, elevated concrete. For the purposes of this case, they all mean exactly the same thing. They're all interchangeable. Elevated concrete might be the everyday conversation. Someone who doesn't know the legal terminology or architectural terminology may call concrete or pavement when it's a little bit elevated, and in this case causing what plaintiff is arguing, causing a trip. Vertically displaced concrete might be the architectural terminology that our expert uses. Hazardous condition, more of a legal phrase. All mean exactly the same thing. So in order to affirm, this court would have to believe that there is no evidence whatsoever, either direct or circumstantial, that plaintiff Colgan tripped on elevated concrete at the subject Circle K. And as long as there's any evidence, then summary judgment was improper and the trial court should be reversed.
Counsel, let me ask you to address her testimony at deposition, which was not, I tripped over this uneven or elevated concrete. It was far more vague than that. What are we to make of that?
Your Honor, that we make that as an I don't know. It's not probative of either tripping on elevated concrete or not tripping on elevated concrete. It's an I don't know response. And Circle K is using that to suggest that that's an indisputable fact that she did not trip on the elevated concrete. That's not what it is. And I'd also want to add, for public policy reasons, if I don't know is sufficient to use against, especially for the purpose of summary judgment, use as a fact that something didn't happen, then it's going to encourage, obviously, the defendants to prolong any sworn testimony, prolong depositions, prolong trial, and say, aha, I win now on a directed verdict or summary judgment because you don't remember one of the details of your case.
But your client has a burden of proof, right?
Yes, Your Honor.
And if I hear you right, her deposition testimony neither supports nor undercuts, would not discharge that burden of proof. Is that fair?
Your Honor, if that deposition testimony was taken in a vacuum, yes, that's correct. we couldn't rely solely on the deposition testimony to prove the fact of tripping on elevated concrete.
And so the question then is, what else is there? And I think you were just getting to that, but please help us better understand what you believe is there.
Yes, Your Honor. And I also want to add that this is not a case where the deposition testimony is inconsistent with tripping on elevated concrete. The deposition testimony is I tripped. I just don't remember all the details of tripped. It was over a year later. She did testify later that obviously her memory is much better, closer in time. So here we have both direct and circumstantial evidence. And I know perhaps people in the audience might have heard, well, circumstantial evidence, it doesn't really mean anything. It's all circumstantial. We may have heard on TV or in everyday communication. And the courts are very clear that direct and circumstantial evidence have the same legal effect. You can actually prove a case just with, or prove an issue just with circumstantial evidence. And the case law is very clear on this point. So first, the direct evidence. We have a statement the day of the fall, and within about an hour of falling and tripping while she's still in pain at the emergency room to her attending physician, Dr. O'Mara, I tripped on elevated pavement. And to make it clear so there isn't...
Counsel, as to that statement that your client made to medical personnel providers, Circle K objected on hearsay grounds, and the court did not rule on that objection. Isn't that correct?
That's correct. The court was silent, didn't address that statement whatsoever or talk about the hearsay exception that were cited in the response as well as oral argument. Your Honor, and there are two specific, one, I think, very specific exception that is straightforward here. First, let me just state what that statement is, because it's directly on this issue. And it's on the index of record 27. Patient states she was walking towards her car at the gas station when she tripped on elevated pavement. So that's very clear. That's exactly what this issue is here. It's whether there's any evidence, direct or circumstantial, that she tripped on the elevated pavement. She says it to her attending physician. And there's two rules that I think it gets in under. One for certain, and that's the statement to a medical practitioner for statements for diagnosis or treatment. As long as it is reasonably pertinent for the purpose of medical diagnosis, and we think one of the reasons we have this rule is because you're not going to fabricate things when you need this emergency help. Here, this was emergency treatment to her doctor, and it describes the mode or mechanism of injury, how she was injured. Certainly that's relevant for the purposes of rendering treatment. She tripped on the elevated concrete, that caused her to fall, and treatment was rendered, emergency treatment was rendered accordingly. Here, and the courts are very clear on what gets in on the hearsay exception, and there's been no case law at all cited by the defendant appellee on this. But courts look at what the primary purpose of that statement to a medical practitioner is. And if the purpose is for the sake of treatment, here obviously it's the day of. She's obviously not thinking of any litigation. She's in serious pain and needed immediate care, was transported to the ambulance from the Circle K directly to St. Joseph's Hospital. And so the purpose was obviously to get treatment by the attending physician.
Counsel, you said it was obvious that your client wasn't thinking about litigation at that time. Where would we find that in the record?
You wouldn't find it in your record, but we have an ambulance transport that can reasonably be inferred, and for the purposes of the rule, we shouldn't speculate. But at that point, and I'd even go a step further, when she is thinking about litigation in the deposition, she's not making that statement. She's stating it when that's the furthest thing from her mind. She's concerned about her well-being, and these were pretty serious injuries. And I know that scope of the injuries aren't at issue here, but from the record, we can see this is an immediate ambulance transport. And it's within an hour, at least when she gets to the hospital, and we have the timestamps on the record, and that's in the index of record 27. But she gets to the hospital less than an hour after this happens. And Your Honor, that State versus Thompson, which is cited by, my phone is, I just want to make sure I have the time. State versus Thompson, which is a case on the rules, and actually it also discusses the excited utterance rules. It does a good job in describing the difference on what gets in under statements for diagnosis and treatment and what doesn't. So in that case, it didn't get in. It was statements to a social worker for the purposes of for forensic purposes. And it compares that with a Robinson case where there's a psychologist that's also rendering treatment. So even though that was still a criminal case, the purpose was to render treatment by to the person that the statement was made to. So I think this very clearly fits under Rule 8034, but it also fits as an excited utterance. It appears to be within an hour of the fall, and certainly she's still in immense pain. There's not that sufficient time to fabricate in this case, and there was no analysis on this in the record. And and there's been nothing citing to those two rules by the appellee in this case either. So we have the clear direct evidence.
As to 8032, the exception to the hearsay rule that you're referencing now, there really is no hard and fast time. The rule simply says the word spoken must be spoken soon after the event, so as not to give the person speaking words time to fabricate. Really, don't we take into account what is happening from the time of the event to the time that the words are spoken, such that in this case there's actually an ambulance transport? I mean, she can actually have time to reflect and decide what to say. I mean, what do you make of that soon after as it relates to the facts of this case?
Yes, Your Honor. The case law, as Your Honor mentioned, was that there's no hard and fast minutes, hours. I think that there's even some cases say days, even if still under the stress. But for this case, because it was a direct ambulance transport to the hospital, this wasn't a case where she went home first, maybe spoke to other people, and then went to the hospital day of. That would be different. Even if that was within just a couple of hours, I think that would be a different case. But I think this clearly gets in 8034, but 8032 I think is certainly in our argument there. State versus Woolery, the statement got in when it was made in response to just what happened as an excited utterance. It wasn't even an utterance unprovoked. It was what happened, and it was stated by a police officer as well as a doctor who were present, and it was 40 minutes after a somewhat similar time frame. And so that's the clear direct evidence, and it's right on point. Circumstantial evidence is very strong here. Here, there is that elevated concrete.
Let me stop you on that for a second. So as you address circumstantial evidence, I'd like you to address what are the parameters, or what's the case law you can direct us to? Now, how do we judge whether evidence is speculative as opposed to being compelling evidence that comes in enough to defeat summary judgment? Where does that tipping point, especially in this case, and especially when we're relying on, or you seem to be relying heavily on circumstantial evidence? So can you address that in your remarks?
Yes, Your Honor. The Farm Arrow versus Henning is a directly on point case in the terms of the issue of causation. In fact, it's the only case that addresses that I'm aware. I don't believe appellee doesn't cite any cases that address causation. And there, causation was proved by circumstantial evidence alone. And Farm Arrow stands for the proposition that as long as the hazard is in the same general location even as the injury, as where the injury occurs, that's at least sufficient for it to go to a jury, for a jury to support that the hazard caused the injury. And this summary was made very clear in Mobilissa. I think Mobilissa, which was a case subsequent by, I believe it was this court in 2007, it summarized it, saying Farm Arrow in parenthetical, holding circumstantial evidence of crop duster plain in general area is sufficient for jury to reasonably infer that defendant company caused damage to plaintiff's lettuce field. So there you have the hazard in the general area of the damage, and that's enough to prove causation. And there was no direct evidence whatsoever. There wasn't even any evidence that the crop duster plane was directly over the lettuce fields. It was just in the general area, and that was sufficient for the purposes of causation. The cases cited, particularly Matt's, that deals with other issues. That deals with notice. It's not dealing with it's not dealing with the sufficiency of evidence as it relates to causation. And here, all we need to show, and which we have, is that the hazard occurred in the same location as where the injury happened. And Your Honor, I point to, and this isn't in the record, and I also point to it again in the reply, because I think it's very helpful, and that is Index of Record 29. It's Kim Acorn's report. He provides a very nice diagram because that's what makes it very clear that the hazard is in the same location as where the fall occurred. And Ms. Colgan's testimony is not that I don't remember anything. She even specifies she could testify even at that point, over a year later, within 1 to 2 feet of where she tripped and fell. She remembers where she was laying at, and she fell first. We also have surveillance video also confirming this is in the same location as where the hazard occurs. But there are 2 vertically displaced areas of elevated concrete, and one is right where, I don't know, and one is right where the fall occurred. So the defense is more than welcome at trial to argue, well, she can't remember now, but at most that's impeaching evidence. That's not sufficient for the purposes of summary judgment or at trial a directed verdict to say, well, there's no way we can possibly conclude that the elevated concrete caused the fall because we have the elevated concrete in the same area that she fell. For purpose of summary judgment, it would be one thing if surveillance video showed, okay, this is in a totally different location. There is no evidence. There's no way plaintiff can possibly prove that the elevated concrete caused the fall. But that's not what Circle K is arguing. They're just saying that their only argument is, well, you don't have any evidence. But we do. We have both direct and circumstantial evidence. And Your Honors, I'd like to reserve a little bit of time for rebuttal. I see I have a little less than 5 minutes left. If there's no other questions, I'll reserve the rest of my time for rebuttal.
Thank you.
Please the court, I'm Wade Causey and I represent the appellee in this case, the defendant in the lower court, Circle K. The court's questions so far are directly on point, and I'd like to address the initial comments made during argument, and that was the interchangeability of the terms. Nothing could be more wrong. And here's why. Let's talk about the basic premises of premises liability law. You have to start with an unreasonably dangerous condition. Not a dangerous condition, but an unreasonably dangerous condition. And for the purposes of the trial court oral argument and for the purposes of this case and this motion, defendant conceded, the defendant, Acorn experts' opinions, that something greater than 1/4 of an inch is unreasonably dangerous. So we don't have to worry about that issue here today. It's not a fact issue. It's not going to change the outcome of the trial court's decision. So let's talk about that. The reason, why does plaintiff make that argument? They want the hearsay statement, okay, of elevated concrete to equate in your minds to an unreasonably dangerous condition as defined by the expert Acorn. Acorn in a 20-foot span of one of 2 seams within 3 feet of each other, in a 20-foot span, look at the diagram that counsel referred to, found 4 spots and dotted them on the diagram as being greater than 1/4 of an inch. Those were therefore the unreasonably dangerous conditions. The problem with this case in a nutshell, and we can go over the specifics and I will, but the problem in a nutshell is that the plaintiffs are asking this court to allow a defendant in a premises liability case, which has never been allowed before in the history of this state that I can find, to let a jury hold them liable, even though it's admitted they may have never come into contact with the unreasonably dangerous condition. They're asking for some type of vicinity rule.
Counsel, where's the admission? You
What admission?
mentioned there was an admission that they'd never come in contact with the
Oh,
unreasonably dangerous.
plaintiff's testimony. And in their oral argument, let's look at the brief. Not only the plaintiff's testimony I've cited, but let's add to it. On the opening brief, page 15, in this court, it is argued, quote, the fall occurred in the same area as the hazardous condition. They don't argue they actually came into contact with it because they don't have that evidence. So they're
And
arguing same
the
area is
same-
enough.
Same area is the admission you referenced?
Yes.
Okay.
They're arguing same area is enough. Well, if we take that to its logical meaning, it means you don't actually have to come into contact with it. That's just basic logic.
And let me ask you, how does the statement for medical treatment fit in to all this then?
I tell you, I believe it's hearsay. I don't believe that you have, how you fall doesn't matter. I've deposed a lot of doctors. I've never heard one say, well, how you fall is going to determine how I fix your leg.
And I understand from the doctor's perspective what you're saying, but the doctor's reporting what she said.
Exactly, exactly.
And it is part of the record. It was not excluded by the trial court, at least as I
Right.
read it.
Right.
And it, as a result, it is hearsay, but it appears to have been found tacitly as subject to an exception to the rule against hearsay and as part of the record that's presented to us.
And I will tell you, I believe it is hearsay. I believe it should have been excluded. There's nothing in the court's ruling that indicates the trial court did not consider it. Therefore, let's consider it. I have no fear of that statement. It's incredibly vague. I tripped on elevated concrete. It doesn't say anything about where. We have to start with where's the unreasonably dangerous condition.
Let's
Okay.
say other evidence would tie it to the where, okay? But what is it about the phrase elevated pavement that you believe is not specific enough?
I walk uphill all the time and the pavement in front of me is elevated. It's so vague. It doesn't take you to that spot. And we have a lot of spots in this area that are not unreasonably dangerous conditions. We have a whole nother expansion joint that their expert deemed was all less than 1/4 of an inch.
Right.
We don't know if she tripped on that.
Don't we know the general, don't we know a fairly specific area? Because that's where she was lying down on the ground after the fall, and that's captured in the photos?
She testified she was walking toward her car from the door. She would have crossed, therefore, if you refer to the diagram that, and I can get you the record of this.
And I understand where she was walking, but what I'm pointing out is that there's only one spot where she was lying down after the fall.
Right.
And unless you're going to suggest to us that she moved
Oh, no.
somehow, I mean, isn't that the location? So aren't we judging to see if there was elevated concrete in that vicinity?
Yeah, let me explain that. Plaintiff testified she was walking very quickly in a hurry, okay? And as she came, all she could remember is that she stubbed her foot or something caused her to trip, not a slip. There's a big distinction. So as she trips forward. She couldn't remember as she was tripping forward if she took 2 or 3 steps before she hit the ground trying to regain her balance.
But isn't there a question of fact here for the jury to decide, and shouldn't the plaintiff have the opportunity, perhaps through expert testimony, to explain how far a person of her stature, her age, her weight, how far she could have flown, if she flew at all, from the tripping point to where she eventually lands? Shouldn't she be, isn't that a fact question?
Well, it is if you get a expert that does that, and I have done many cases where we've had those experts. Plaintiff didn't choose to put that expert in today, so we have all this vague testimony, which takes us back to the original problem and why the trial court judge was correct.
Counsel, let me. I want you to get to that
Okay, go
original
ahead.
problem, but I have a question before we go there.
Okay.
Are you saying that plaintiff in this case and others like it would need expert testimony to help the jury decide where someone fell?
I think to address Judge Cruz's question, yes. Now, whether or not that's required in a given factual scenario and case, it would depend on the case, a case-by-case basis, I believe. But to specifically answer Judge Cruz's question, yes, I believe that is the subject of expert testimony, because I don't think it's within the province of the normal juror. So on that particular case, as far as the problem we get back to is, and I can talk about circumstantial evidence here in a minute. I don't really care about the distinction in this case, because what you have to have is evidence, call it direct, circumstantial, whatever you want.
And the
that-
law does not distinguish between
It
direct
does
and-
not.
right.
It does not. But you need evidence that's going to tell you, when you have the burden of proof, as Your Honor pointed out at the very beginning, it's not enough to take all the possibilities and they're all equally plausible. The evidence must tell the jury which one is more plausible, thus preponderance of evidence at 51%. 50-50 is insufficient.
And counsel, I agree with you if we are on a motion for judgment as a matter of law after the evidence been received or after the jury considers the evidence and rejects it in a verdict, but we're not there. And is the standard that you're positing the standard that applies for summary judgment?
It is. I mean, we can go back to Orm School, and I have it briefed this. I think Orm School may have been cited in my initial paragraph regarding the standard. Sure. But since then, there's been 20 other cases that say the same thing. And that is that the quantum of evidence is weighed against the standard regarding the burden of proof as if it were at the directed verdict stage. Okay, the cases specifically say that at trial. And that is the summary judgment standard. So in answering your question, absolutely. Absolutely. I think that's very clear. But as far as what we're trying to get here, let's look at the effects of a ruling that says this is enough evidence. What's vicinity? What's in the area? What's close enough? How are we going to instruct the jury? What is it, 2 feet, 4 feet, 6, 8?
Counsel, how was it enough? How was it enough in the crop dusting case?
Oh, I would love to address.
Where the plane flies over and it sure seems like it's kind of fuzzy, kind of general vicinity, good enough, good enough, maybe.
I love the crop dusting case.
Go ahead.
First and foremost, with all due respect to the court that wrote the opinion, it has nothing to do with legal causation. It has to do with identifying who the proper defendant was. Okay, there was no question that the chemicals that had been dropped are what caused the damage to the other person's crops. And in this scenario, that would be the legal causation. The defendant was saying it wasn't our plane. So let's look at the evidence. And I'm reading here from page, on the Arizona Reporter, it's 241 on the Arizona Reporter. It's Arizona app, 23 Arizona app, 241. And the court goes through it. First and foremost, there's evidence from the state pesticide board, the board control, that says that defendant's plane was the only plane authorized within 6 miles of this area where the damage occurred on that day to fly. Okay, and of course we have state regulations then, of course, through the State Board of Pesticide. 2 witnesses testified to seeing the plane and seeing its color. If you read this evidence here, and it was a Grumman Cat biplane, whatever that is. I'm not an aeronautics person or a plane person, I apologize. What they're doing is, and they talk about yellow wing tips. It's gray with yellow wing tips and red. This is what I call direct evidence. They call it circumstantial. But what they're doing is here, they're just identifying the defendant. Well, we know who the defendant here is. Here it's Circle K, it's our store. We're talking about legal causation. We're talking about a specific condition under premises liability law that you have to at least come into contact with it and have evidence that you came into contact with it.
Well, that's one way to look at Farm Arrow, but could we also look at this case as a case where we knew that that particular plane had been flying on that day, but did that plane fly over this particular field on that day? Did that plane cause the solution to be sprayed over the lettuce, this particular lettuce field?
Well, I think the evidence that was put on in that case, which we don't have anything remotely close to that here, is that that was the only plane from that defendant's company that was allowed to fly in that area that day. So it had to come from that plane.
Well, they weren't disputing that they had flown that day, were they? They were
No.
disputing that they flew over this particular field.
Right, right.
That they caused the pesticide to be dropped over the field.
Yes, and all of this evidence that this plane was the only one flying in the area, even though it was allegedly doing it next door. I think it was saying the property next door. and it didn't get over. So I don't know really whether they were arguing. I'm not sure the court distinguishes that the plane sprayed the wrong field or that it drifted over into that field. But either way, there wasn't an issue that the chemicals at issue from that plane that were being dropped next door, and they admitted being next door, if I recall. It's not really an issue of what caused the damage. It's who put the chemical out there. Well, in our case, we're not arguing that we didn't create. There's not a notice argument here under premises. It's our driveway. It's our gas pumps. There's no argument about that. It's more specific, and in premises you have more specific because you're required to have an unreasonably dangerous condition, and then we get into duties of remediation or warning or things of that nature or reasonable inspection. But first you have to have an unreasonably dangerous condition, and it has to have caused the incident. You can't have that if you allow a jury to determine fault without any proof that anyone ever came into contact with it.
Counsel, let me ask you hypothetically, what would plaintiff have needed to show from, in your perspective, to defeat summary judgment?
Most cases you have an eyewitness, or the witness is able to, as they sit on the ground, look and say, there's that crack, or there's that object within a couple of feet of my foot, and that must have been what I stubbed my toe on.
So Ms. Colgan's testimony, for example, could have accommodated your concern if it came out differently in this hypothetical circumstance.
Exactly. In fact, Ms. Colgan's testimony is key here to show that there isn't the evidence they need to get there.
And let me ask, there was, at least at one point in time, surveillance video of this area that didn't survive. What are we to make of that?
Well, there's a problem with the spoliation argument. First of all, I don't believe it was ever properly presented at the lower court level.
And to be clear, I don't see it featured prominently in our briefs, without question. Yeah. But what are we to make of that?
I'll be happy to cover it. It's not in the brief, but to answer your question, the way the video works, this was an older system. They're all replaced now. The way the video works is you go in and you put in time parameters. So I want it from 1:00 p.m. to 2:00 p.m. and it will then take it off the system, assuming it's still there, which I think on these systems was a 30-day rollover, and it will then copy that down onto a disk or whatever you copy it to. What happened in this instance is the store managers are the ones who do this under certain circumstances. Most of the videos are actually, and the cameras are placed strategically and specifically for criminal activity. Sure. Most of the videos are copied and given to the police, quite frankly. Right. They're not there to catch people falling or those types of things typically. In this particular instance, the parameters of the time, were not entered in correctly. And so what happened is, in the video we do have, you see her on the ground. You just don't see the fall, the actual trip and fall. But I'm not sure, and this is always part of the spoliation argument, if you will, and to gain any type of inference, you have to show that had the video been preserved, it would have shown something that would have told you the answer to the question you seek. And without that evidence, the spoliation arguments typically fail.
Well, and one question with that, and then because you're right, it isn't featured prominently in the briefs, but isn't that sort of circular, what you just described, to show that spoliation instruction or inference should apply? You have to show that what we don't have would have helped you, and nobody else is there to say that. That seems...
Oh, I've seen it done. They hire an expert, they go out, they take our cameras, they look exactly the same direction of what we already had, or they get testimony from people that say they haven't been moved. They're still pointed in that direction. They then get the system, and they will actually, I've actually done it, and they will actually then have a person walk or go out there and then go back and look at the video and see, would it have shown it if we had it? And so it's recreatable. It really is.
Counsel, I thought the manager actually viewed the video of the fall.
Yes, but typed in the wrong numbers.
But he has no recollection of what he viewed?
he couldn't recall from what I remember as to whether or not she tripped
But
on.
isn't that a bit ironic that he couldn't remember, and then in light of the emphasis on the deposition here?
Yeah, to a degree it is, except I've watched the video that we have from that angle camera outside. I don't honestly believe that you could have seen what her feet tripped on from that distance anyhow. It's a long way away.
So counsel, getting back to the hypothetical Judge Thoma posed in terms of, and asking the question of what would have been sufficient for the plaintiff to get over summary judgment hurdle, slightly different. What if we had the circumstance where we don't have the video, such as we have circumstance we have now, but not to be too dramatic, but if the plaintiff had not survived, if she had fallen and it had been a fatal fall, then there's no cause of action unless someone is there to give direct testimony that they saw her trip in this specific spot and fall?
I would say that if there are, like in this case, a number of areas within the area at issue that are not unreasonably dangerous conditions and someone could still trip on. Because basically what we're saying is, we're almost trying to say, and nobody said it yet, well, people only trip if there's something wrong with the ground. And we know that's not true. It happens all the time. I trip over the carpet in my living room. We're human. And I don't think the law is prepared to take on that presumption under the premises liability law. So yes, unfortunately, I think in your scenario.
I think what we're trying to say is what the Farm Arrow case says, that circumstantial evidence can be as persuasive as direct proof when it provides the basis for a reasonable inference as to the ultimate fact. So that really is the question here, whether the place where she finally falls leads us to a reasonable inference that this unsafe area, this concrete near her, is what caused her to fall. So
Right.
that's really the question, is would that be a reasonable inference, isn't it?
Within that entire area, their expert within that entire area found 4 spots and marked them on the diagram of greater than 1/4 inch.
So your position is that it would be unreasonable to say that, or to infer that the place, given the other areas that were safe, to infer that that would have, that the raised concrete at one particular location would have caused the fall.
I believe the evidence in this case at best establishes that all of the possibilities are plausible equally. And that does not meet the burden of proof.
Thank you.
Thank you.
Your Honors, I want to just quickly go to the Orm School because I know that was cited. That was a case that it basically dispelled the slight evidence. It wasn't that there was no tortfeasors here. It was there's a less than 1% chance that Orm School was the tortfeasor, 99% or more that the other company that was the tortfeasor, and nobody could pinpoint which meal caused the plaintiff to get sick. And a reasonable jury would think, well, I have at least 99% odds. It can't be Orm School. So that's what that case stood for. It just dispelled the slight evidence. It's not that if it would have turned differently if it's equally as likely as Orm School and I think it was College World Services or something. The other company was at fault. Summary judgment in that case against Orm School wouldn't have been proper.
But you agree that the summary judgment standard and the judgment as a matter of law standard are comparable, right, after Orm School?
Yes, Your Honor.
Just on a somewhat different record.
Exactly, Your Honor. And Your Honor, I think you hit the nail on the head with and I know Judge Brown had asked about the Farm Arrow service. It does deal with causation. So the identity issue was defendant argued, well, my plane was never over your lettuce fields, and the evidence didn't show it was over the lettuce fields. It showed it was at an adjacent land. But that was still enough because it was in that general location and the evidence didn't show it could have been caused by something else. Here, we have the general location. In fact, we have a pretty specific location. We know the record establishes that the fall occurs and she's laying somewhere between pump 2 and pump 4 close to pump 2. Well, lo and behold, you have the hazardous condition right there. It is consistent with the surveillance video. If the surveillance video showed she's laying in a totally different direction, that's one thing. The Circle K could argue, well, the evidence that's been produced doesn't show here. Here, it's reasonable for a jury to infer that the elevated concrete occurred right where it is, where occurred to cause the fall. And this is not an admission that all we need to prove is a general location for a jury. It is just the general location is sufficient to prove that the elevated concrete caused the trip. It's sufficient circumstantial evidence for a jury to infer the elevated concrete caused the trip. We are not conceding, we're not stating the elevated concrete didn't cause the trip. We're saying the elevated concrete is in the location where we know the trip occurred. And it's a very specific location in this case, much more specific than Farm Arrow. It's between pump 2 and 4, near pump 2. That's what the evidence says. And all along the seam, it's over 1/4 of an inch, which is unreasonably dangerous. There's not elevated concrete anywhere else in the area, so it can't be some other elevated concrete. The only other areas are flush. So the only elevated concrete is what the expert testifies vertically displaced over 1/4 of an inch.
Counsel, what about the notion that tripping is sort of a part of everyday life, as opposing counsel suggests? How do you address that?
It is, Your Honor, and if there wasn't an unreasonably dangerous condition there, then that's one thing. But here, all we need to show is that it's reasonable for a jury to conclude that the elevated concrete caused the trip, as opposed to something unrelated to the elevated concrete. And here we have the trip hazard right where she fell. We also have the direct evidence, the evidence that she stated at the emergency room. If that evidence gets in, we don't even go there. But, Your Honor, this is a case, we don't even need to address all of the evidence. We can just look at the circumstantial evidence and the courts hold that's enough. We can go to the direct evidence, that's enough. We don't even need to address both this direct and circumstantial evidence. I'm using it to show that there is more than enough evidence here. All you need is one or the other. Here we have both. We have both direct evidence and we have circumstantial evidence. Neither were addressed by the court below in granting summary judgment. Thus, summary judgment must be reversed. If there's no other questions, that's all I have.
Thank you, counsel. Counsel, we thank you for your arguments. This matter will now be taken under advisement, and we thank those members of the community that came out to listen and see how your Court of Appeals works. We welcome you to visit us down at the Supreme Court building downtown in West Washington Street. If you want to see more, we usually don't have an audience, but you're always welcome to come observe. Thank you. That's all.